Hello, everyone. We are here for the first podcast of Construction Law and Arbitration Vertical at Dhirubhai Ambani University School of Law. So, we have two experts today who will be discussing with us on construction law and arbitration. First, we have with us Mr. Mohit Dubey, who is a UPSC 2012 batch Indian Engineering Services Officer working as Deputy Director in Military Engineering Services under Ministry of Defence, Government of India. With rich and diverse professional background, his area of interest includes construction management, dispute resolution in construction sector. We have also a well-known figure in the field of construction, building technology and construction management, Professor Murali, who is Assistant Professor in the Building Technology and Construction Management at IIT Madras. Sir is also expert in the specialized area of construction contracts, claims management, construction dispute resolution before joining IIT Madras in June 2023. I welcome both of you, the experts for this particular podcast. Over to you, Mohit Dubey, sir.
Thank you, Dr. Niteesh. It is my privilege and honor today to be here in your first podcast and discuss with Dr. Murali, who is expert in the field of contract management and construction law in IIT Madras. He is a leading figure in this domain and industry. I have learned a lot from him since last couple of years. So today the topic is the need of legislation, or what I say, need of construction law in the Indian construction industry. So it's a relevant topic and it's very close to my heart, as well as I know with Dr. Murali as well, because the requirement of construction law in the present contemporary Indian context cannot be underestimated, where we are having ups and downs in last 2 to 3 years. Together we have also contributed on the same topic a chapter in the book which is going to be published very soon. And the background is that we were discussing and we brainstormed and we were thinking that in last couple of years there have been few decisions. For example, a very famous OM issued by Department of Expenditure, Ministry of Finance, which restricts use of arbitration in construction projects having claim value less than 10 CR. Then Government of Delhi taking out the arbitration clause from all their works contract, and very recently Ministry of Law endorsing the OM issued by Department of Expenditure of last year, 3rd June 2024. So with this background, we were contemplating that what should be the scope, nature, and of course the requirement of construction law in the present circumstances. So with this background, I welcome Dr. Murali to this podcast, and we will begin with the discussion. So Dr. Murali, my first question to you is that exactly what does the word construction law imply for professionals in the construction industry?
So thank you very much, first of all, Dr. Niteesh, for inviting me to this podcast. And it is really wonderful to be here amongst all of you to discuss this, again, very, very interesting topic, and which is close to my heart as well. And thank you, Mohitji, for the introduction and also for the question. So let me put it this way. So to answer this question, probably I need to just elaborate a little bit about the background and then come to the point on what, in my opinion, is a construction law and how it makes a difference to what is actually happening. Now, we all know, so this construction industry is one of the most important industries that is driving the economic growth. It's not only the case of India, but in any country, a vibrant construction industry is synonymous to the growth, right? They say that when you look at the skyline of a city and you find a lot of tower cranes, it means that the country is growing, the country is developing. That's quite good. And also construction industry is one of the largest employers, right? They employ millions and millions of people. So the health of the construction industry is one good indication of how good is the economic development and progress in that country. All these things are good, but on the other side, the same their very important construction industry is also fraught with a lot of problems, which is not something new, but this is being existing since along with the day on which the construction project started, and still the same kind of problems still continue. So if you look at these reports like Ministry of Statistics and Program Implementation, MOSPI report, even if you take the latest, that is a report that is available, you can see the extent of time overruns and cost overruns. About 50% of centrally funded projects are delayed, and on certain kind of projects, not that all kinds of projects, certain kinds of projects it is delayed, and the cost overruns runs to lakhs of crores of rupees. So again, if you look at in all these kind of issues of time overruns and cost overruns, if you look at the core of these kind of issues, you have the disputes between the parties. It's a contractual disputes between the parties. And the moment we say a claim or a dispute, because once there is a delay, one of the parties affected, either the client or the contractor or both, they incur losses, and automatically there is a need for claiming for compensation and things like that. So when all these things happen, parties immediately look into the contract to see how do we solve this problem. So what does the contract say? Who is liable for this particular issue, and what is the compensation by one party to the other party? Who is the breaching party? Who is the non-breaching party? So all these things we will start looking into the contract. Now, contract is ideally supposed to answer all these questions and pave the way for dispute resolution, but let alone solving the problem. Many times a construction contract is a source of problem, right? And because of the way it is drafted, because of the way it is conceived by the parties. And this is where we need something like a legal we need something like a law which has certain fundamental basic principles that makes parties bind, right? So that's where the law comes into picture. So when there is a problem in how we resolve the disputes through the contract, so we start looking at what is the legal solutions that are available. Of course, a contract has to be drafted within the legal context that is there. But of course, if something is not clear, then we resort to the law. And now we have Indian Contract Act for the contractual disputes. Indian Contract Act is a very well thought of, very elaborate, and since it exists, since it's applicable, since 1872, it shows that how much forethought was there when this particular law was drafted. It is a very well written law. But the issue here is that construction sector as a sector is so unique and so complex that the Contract Act, which is actually right now in India is applicable for all kinds of contract, a general act that is applicable for all kinds of contract. And if we start extending that to construction sector, things become slightly complicated, which we are going to discuss as we proceed through the discussion. I'm sure of it. That's where we need a law that is specifically for the construction contracts to govern the transactions in a construction project. So when I say construction law, law on construction for law governing construction projects, it only means contractual disputes that I'm saying, but it can also extend to a whole lot of issues associated with taxation related to the construction, again land acquisition, again related to construction, the health and safety issues relating to construction, can cover a whole lot of things which can be tailor-made for the sake of construction projects, and that can make a whole lot of difference in terms of people who are trying to resolve the dispute. So there's a clarity, disputes can be resolved faster and in a time-bound manner, and in a manner that can help reduce the resolution cost, dispute resolution cost. So therefore, construction law per se can bring in a lot of difference. Specific things that I think we can discuss as we proceed further. This is what I look at construction law as.
Thank you, Dr. Murali. So what I understand is that we need construction law for the certainty,
Right.
to remove the ambiguity,
Right.
to help bring a clarity between the parties that what are their rights and liabilities.
Right.
And this will also go to an extent of not only minimizing the disputes, but also if there are any disputes, then it will help in faster and efficient resolution of dispute.
Absolutely.
The one thing which I would like to highlight, which Dr. Murali brought out, that construction law doesn't get restricted only to the construction contracts per se. So it has got a very huge, wider implication and ramifications. For example, if I quote here Julian Bailey from his very famous, celebrated work on construction law, he defines construction law as construction law is the law that applies to and in respect of the undertaking of construction and engineering projects. So Julian Bailey explains that the definition is not confined to construction contracts or a specific or identifiable body of jurisprudence. It is a definition that embraces the totality of legal issues that may arise from a particular field of economic endeavor. So, as Dr. Murali rightly said, that it encompasses all the various facets of the construction, be it labor laws, be it health and safety, be it let's say payment and security, and taxation, and of course dispute resolution. So it's not just what we are talking here is restricted to bringing any one legislation or one act, but probably it's entire code or law what we are talking here. So now moving to the next question, Dr. Murali. So I would like to discuss with you that what is the status of construction law presently in India? Do we have anything like construction law as of now or not? And if not, then what could be the issues or problems that could arise in future?
Okay. So right now, if I just look into the contractual disputes or dispute resolution as such, so we have the Indian Contract Act that puts down what leads to the formation of a contract and what would consider to be a breach of the contract and what is the implication of breach of the contract, what happens to the breaching party, what happens to the non-breaching party, or the Indian Contract Law. So we also have an Arbitration and Conciliation Act that governs the procedural aspects of how arbitration has to be conducted and things like that. Both these acts, as I told in the first, while I'm replying to the first question, are general acts. It's for all kinds of contracts, all kinds of disputes, commercial nature, if you take arbitration, commercial disputes. There is nothing specific to the construction contracts as such or construction projects as such. However, there has been a lot of debate on this, and courts have come up with some kind of interpretation of how these Contract Act or Arbitration Act will come out when it is applied in the specific case of construction, and that's the jurisprudence that is available with us to follow when we try to resolve construction disputes. So to put it in a nutshell, there is no such construction-specific, fully dedicated law that can govern construction projects. Now, coming to the next part of your question, how does it matter? Does it lead? Start with a very simple example. Let's take an example of a construction project, and let's say that the project is 2 years duration, right? So starting to completion, 2 years duration. And assume that 1 year has gone by, and now we are at the end of the first year. So we still have 1 more year to be completed. And let's assume that there are 2 buildings to be constructed, building A and building B, and completion of both building A and building B is deemed to be the completion of the project. Now, building A has reached the stage of mechanical, electrical, and plumbing, which is a very advanced stage. And only 2-3 months of work is remaining. That's all. And building B is in the foundation stage, which is in the beginning stage. So which would easily take 1 more year to complete, and that marks the complete of the entire project. Now, the building A, where the mechanical, electrical, and plumbing works are in progress, civil construction is done, electrical, mechanical, plumbing, and finishing work is progress. Only 3 or 4 months of work is remaining there. And suddenly, the contractor sees that the employer has slowed down the rate at which the drawings are being issued for construction. There's a delay in getting inputs from the client. The contractor writes back to the client saying that you are delaying the issue of drawings. This is leading to the prolongation of the work that I'm doing in the building A. And this will cause a lot of losses to me in terms of, because of the delay. I'll have to extend my resources. I need to plan out. I need to ensure my engineers are still continuing to exist in that particular section. And there are so many complications that my sequence of work is disturbed. A lot of issues go on. Therefore, you might have to compensate me for all these delays that is happening because of your late issue of drawings. The employer comes back to the contractor and says, how do you say that there is a delay in the project? Because for an employer, the delay is a delay when the entire project gets delayed. Now, what is happening here is that the building A drawings are getting delayed, but the employer's argument is it's okay if I delay the issue of drawings because you still have one more year to complete this work. Because anyways, the building B is still in the ground floor, in the foundation stage. So you still have a lot of time to do it. So why do you really bother about project getting delayed? And only if project gets delayed, you can talk of compensation and all those things. Now that only this building might get delayed, you'd have time. So why do you really bothered about asking me for the drawing? So it doesn't matter anyways. But actually, what is happening here is that although in terms of the contractual language, there is no delay in the project, there is disruption to the project. The contractor's planning gets affected. The productivity losses are there. And therefore, this causes an impact to the contractor. And contractor puts up, that's why the contractor is asking for drawings and expediting and all those things. Unfortunately, the way we draft our contracts, we don't consider this as a delay at all. Now, with a lot of foreign companies coming into India and Indian companies going abroad, the concept of loss of productivity claim or disruption claim is gaining ground. And the fundamental premise of a disruption is that there need not be a delay to the project, but there can be a delay to an activity which is not on a critical path, but still considered to be a delay. Now, these kind of issues are not clearly explained anywhere in the form of a law. That's where confusion starts. Right. So when you ask for compensation, the employer denies the compensation, saying that this is not a delay, and that's where things go on all the way to the court. So this is one such example where there is no clarity. I'll give you one more example. Let's take the example of liquidated damages. Now, liquidated damages is something that's the clause which is there in the contract. In most of the construction contracts, we have the LD clause in the contracts. Now, if we look at these LD clauses, they are governed by Section 74 of Indian Contract Act. And according to that particular Section 74 of Indian Contract Act, when there is a predefined amount agreed in the contract, which is nothing but an LD clause, the non-breaching party is liable to pay compensation to the breaching party, whether or not there is proof of that particular losses incurred by the non-breaching party. Now, anybody who reads this would first immediately assume that to put a claim titled liquidated damages, one need not give any proof for it. That's what immediately strikes. But if you look at the Section 74, the very last line of Section 74 also says that this amount that is being claimed by the employer under the name of LD, because these are not the exact words, I'm just paraphrasing it so that it would be contextualized in, and this is again a problem. Nothing is in the construction language, right? I'm just contextualizing this in the construction language. So whatever employer asks in the name of liquidated damages should also be reasonable in nature. Now there is a problem. One side, there is no need for proof. On the other side, it has to be reasonable. And how do you prove the reasonableness without actually proving the extent of damage? So this has been debated in the court, and there's been a lot of discussions in the court, and courts have repeatedly held that the word whether or not proof is required, it doesn't mean that proof is not required, but it only means that wherever it is possible to prove, it's the liability of the employer to prove, and wherever it is not possible to prove, it is not required to prove, and this LD amount, subject that it is reasonable, to be considered to be the reasonable amount of claim. Now again, what are the conditions? What kinds of projects are said to be projects where the losses can be proven? What kind of projects are said to be the projects where losses cannot be proven? Again, that is not clear. Right? So this is where the availability of a clear construction law can help in putting these points and clarifying these aspects so that there is no confusion when parties are operating these clauses to execute the projects. And again, just to add to this point, now that reasonableness has to be established. Now, employers do many things. Let's say, for example, I am an employer. So I have a civil contractor under me who is working with a separate contract, and I have a mechanical, electrical, and plumbing contractor working under me separately. Now, sequentially speaking, MEP contractor can start the work only when civil contractor hands over the civil completed site to the MEP person. Now, let's say that civil contractor delays. Now, the MEP contractor is already onboarded, and the MEP contractor starts coming to me and says, where is my site? How do I start? I have mobilized my resources. You are not handed over the site to me. Now, I cannot tell that, no, my civil contractor is not given, therefore I am not able to give you. For the MEP contractor, I am the client, so I have to give the site. I might have 100 problems with the civil contractor. Now, the MEP contractor would again say, slap a claim on me, saying that they would be needed to be compensated for the delay that's caused by me. I cannot take that particular claim and transfer it to the contractor and saying that, see, compensate my MEP contractor's losses, because this becomes third party loss. And Section 73 says that losses have to be direct. Now again, what conditions are direct and what conditions? And this particular example, what I told you, is available as a small illustration under Section 73. Very small font size illustration. This is actually a very big problem in construction sector. This needs a whole lot of elaboration. So these are the points. I can go on with a lot of examples, but for the paucity of time, I just restrict it here. And it would make a lot of difference if we have a construction law in place. Mohit, you're smiling.
I can appreciate and understand your anguish with so much of ambiguity present in construction industry and especially the construction contracts. But yes, sir, I fully agree with you. So what we can summarize by saying is that presently, as of now, there is no specific law with respect to the construction industry which could bring the clarity. Whatever exists in the form of a general statute, be it Contract Act 1872 or Arbitration Act or any other act, labor codes or wages. But for example, there is nothing which is explicitly existing with respect to the safety and security, health and sanitation of the laborers working at the construction site. So we are presently lacking the clear and very precise statute specifically targeting the construction industry, and the issues like what if there is no construction contract. So as you have rightly pointed out, there is so much of ambiguity. There's so much of non-clarity. For example, exception clauses are there, escalation clauses. CPWD has a different formula and nomenclature, and the timelines for the application of escalation clauses vis-a-vis. If we compare MES, my department, we have different set of escalation clauses. Then the definition of terms, for example, cancellation, termination, determination. So what CPWD explains determination as like, if I'm correct, you may correct me, sir, that determination is when the contractor is at fault and the department can, cancel the contract. We define determination as nothing but foreclosure. And then there is nothing called determination which is being explicitly defined anywhere, in law or everywhere. FIDIC has determination where it talks about actually bringing the differences to a logical conclusion.
More of a reconciliation process between the client and the contractor. The engineer gets involved. Yeah.
So just to settle the difference of opinion, that is what determination is. So if we bring an act which would clearly specify all these legal terminologies, because when they reach to the court, courts give a different interpretation depending upon the background and the characteristics of the construction contract and the department as well, and their history, of course. But this is not resolving the problem, because the standard form of contracts which we practice, especially in government, we tend to have a habit of putting every now and then a clause which suits our requirement and which protects us from any future risk without understanding its legal connotations and how it will fall out. So yes, it certainly adds to the dispute and without bringing any clarity. Anyway, sir, we will move on to the next question. Is that then what should we do in this regard? Should we enact a code, or if you can put some light on this, sir?
I strongly believe that there should be we should enact a code which can govern the construction contract from the conception till the commissioning or even operation and maintenance, I would say. So again, this is easy to say, but the next thing would be what to put in this. Like what should be the contents. There can be many things. Like I can just highlight a few things which is just coming to my mind. Like for example, Mohitji was talking about drafting a contract. So now this law, one of the component of this law should be, so what should go into a construction contract? Although contract, the how you contract is the freedom between the parties, and that the judiciary respects that freedom. It doesn't mean that you can have a contract which is which is say unfair to a great degree, or which is one-sided, and which tries to exploit the possible desperation of the contractors to get a contract. Now, I'm not sure whether I'm putting the right words here, but what I'm trying to say is that there should be some kind of guiding principles to draft a contract. It should be an essential part of this law. Because there's a lot of substantive issues that the law should deal, but there should be certain procedural aspects with respect to drafting of contracts also that the law should deal with. Let me give an example. Mohit was talking about the use of certain terms, which same word used it differently in different contracts causes a lot of confusion. Now, let me give you one more example then. In most of the construction contracts, employers have the habit of writing this. Time is the essence of contract. Now, the moment you say time is the essence of the contract, the meaning is the employer is very, very strict in terms of completing the project within time. So any delay is unpardonable. The Section 55 of Indian Contract Act says that if time is the essence of the contract, and if the committed party is not able to complete it on, then the non-breaching party can even terminate the contract. Right. So it's the power that the employer has if the contractor is unable to complete the project on time. Now, time and again, courts have ruled that time cannot be an essence of a contract whenever there is an LD clause also available in the contract. The moment there is an LD clause, there is a liquidated damage clause that is available. The meaning that comes up with this is that on one side, you are saying that time is the essence of the contract, timely completion is important. On the other side, you are talking about extension of time. So these two things are not sitting well with each other. So making time as the essence doesn't make sense in this particular case. And this is something that is said by the court time and again. But even now, there are ways to deal with it. So there are ways to deal with it. Let's not elaborate on that right now. But although there are ways to deal with it, even now, if you see the way the construction contracts are drafted, they are drafted with time being the essence of contract on one side and liquidated damage clause on the other side. This very point is actually being exploited by certain parties to the contract, especially when you're a contractor. This particular ambiguity between on whether time is the essence of or not actually gives rise to the position that time is no more the essence of the contract. When time is no more the essence of the contract, all such kind of no damage clauses are not applicable, because paragraph 2 of Section 55 Indian Contract Act says when time is not the essence of the contract, you cannot terminate the contract. The project has to be completed within reasonable amount of time, and the party who has delayed, responsible for the delay, has to compensate the other party, although maybe at actuals, but compensation is definitely to be made. In all such cases, your no damage clauses saying that only extension of time will be given, no cost compensation would be given, all these things go for a toss. Right? So what I'm trying to say is that this particular discipline of how a contract has to be drafted is actually to be brought in, and this law can make a difference. Let me give another example. As I speak, I'm able to recollect one more example. One peculiar aspect of construction contract is that it is not a simple material procurement contract. Like it's not that I give money to purchase a machine, a product. A lot of things get into the formation of the contract. Mohit would have seen when MES prepares a tender document, so much of information should get into this tender document. Different sources. So you have the engineering team, you have the commercial team, you have the technical team, you have the client who is the Army, Air Force, Navy. So they provide a lot of input. So all these inputs have to get into something called a tender document, and that is released to the contractor. It is highly likely that there can be ambiguity between drawings and specification, between the general conditions of the contract, between two different clauses of general conditions of the contract. That's where acknowledging that there will be ambiguity, you have clauses on order of precedence. Now again, in many contracts, we don't even find the order of precedence clause at all. This gives rise to a lot of confusion. So this act, if it is there, it can say that at the minimum, so act should not dictate what should be the order of precedence. It is left to the parties to decide what should be the order of precedence. Act should at least say that there should be a clause on order of precedence whenever you have multiple sections. There is highly likely that the different sections can have conflicting information, so that some thought would go into the mind of the people who are drafting the contract. Think about it and put down something. I'm not saying that it's going to solve all my problems, but at least a majority of problems could be solved. Recently, I was going through a contract document. I don't want to mention the name of that particular, it's public sector organization. There is an important rule called rule of contra preferentum. So whenever there is an ambiguity in the contract, if the contract does not provide a way to resolve this ambiguity, if the contract is clueless about how to solve this ambiguity, then the rule of contra preferentum comes into picture, according to which person or the entity which has drafted this ambiguous contract, against that entity, the ambiguous clause will be interpreted, which means it will be interpreted in favor of the party who has not drafted that particular clause, ambiguous provisions. This is called the rule of contra preferentum. Interestingly, in this particular public sector contract, I saw that parties have it's a clause in the contract that this rule of contra preferentum will not be applicable. So now, how far all these things are tenable? So this is where some discipline is required, and some guiding principles would be required, and this is one of the aspects in the construction law that I would look for. Another is the procedural aspect. Again, when I talk about arbitration, so Mohit also would agree with me that what is the scope of an arbitrator many times becomes a problem. Whether the arbitrator has to stick to what is there in the contract and exactly see what is there in the contract, and that's what many people say, that arbitrator is a creature out of the contract, so therefore arbitrator cannot go out of the contract and things like that. On the other side, there are judgments wherein the courts have said that certain things like no damage clauses are restricted only to the department, but arbitrator is free to interpret on it and take a plausible view. So these are the certain confusions that are there which needs to be brought in. So this is what should be brought in into the construction law. This needs a lot of thought, debate, a lot of inputs from many sides. Otherwise, this would again become narrow and it will become a source of dispute again. So therefore, this needs to be given a careful thought. Yes, Mohit.
Thank you, sir. I think you have touched the most vexed issues in the construction, industry and the disputes. And when you were talking about this plausible interpretation and the scope and the ambit of the arbitrator, where he's the creature of the contract, it was actually said in the Ramnath International versus Union of India.
Yeah.
It is a MES dispute, and very famously interpreted by all public sector organizations in their favor. And even the courts, they also, have a practice. I would not say practice, but their judgments are also vulnerable to, get changed or, sometimes upside down. Because if you see this Dampel versus DMRC, when when it first came to Supreme Court said, and if I remember it very correctly, they said that any arbitral award published by engineers, it should not be interpreted and it should not be seen from the lens of the legally trained mind. So they gave this plausible interpretation, and they said that award given by engineers have to be upheld if there is any plausible interpretation of the award possible, which is legally correct. But the same, dispute, when it went to the curative petition under Article 142, Supreme Court exercising, extremely rarest of the rare powers, and turned it upside down and said the arbitrator has done grossly wrong when they missed out a very important clause in the contract. So, even the courts also are not immune to the reversion in their judgment oblique the perception towards the construction industry. So, as Dr. Murali has rightly said, that we need to bring a clarity. And if there is a statute, there is a law which says that, for example, you need to have documents to set an order of precedence. You need to have clearly defining the clauses where liquidated damages are also present, and of course the time is the essence of the contract, and so on and so forth. The banning of contractor. I mean, MES. And so correctly for the other construction departments of Government of India, where when there is a big contract coming and the contractors are in the habit of approaching high courts to get a stay against, a particular tender on some or the other ground that they have not been, considered violation of Article 14 and not giving rightful opportunity to hear. So the courts have blocked such kind of interference by the contractor, and they have said that accepting officer has to be given due respect and their decision has to be honored. But you never know. I mean, sometimes a court can say that no, this particular work or tender has to be stopped. So we need a statute. We need to have some clarity where you should clear the air. You should clear all the issues which may lead to potential disputes in future. Thanks a lot, sir. And now moving to the next question.
Okay,
That
Mohit, just before you
yeah,
go
yeah,
to the
yes, sir.
next question, I'm sorry, I'm tempted to again cite one more example, which I'm sure you would support me with more light on that. Another issue is this bank guarantee invocation, right? So stopping the bank guarantee invocation going to the court. So what are the conditions? So I see this very commonly. The contractors run to the court, and the very purpose of bank guarantee is to give the protection to the employer that under especially unconditional bank guarantee. I'm talking about unconditional bank guarantee, irrevocable bank guarantee. So there are instances where courts have intervened and said, okay, under this condition, they call this as irreparable injury and fraud of huge nature. Like those are certain situations that are there. Again, this all exists in the form of precedents. Now, for a person who is dealing with contract on a day-to-day basis, it might be really difficult for getting a legal opinion for every small matter that they're dealing with. And if they start doing that, they might probably not be able to do the regular work that they are doing. And that's where this kind of guidance should be there. And even I think some time ago we were also discussing about the payment issues.
Yes, sir. Yes.
Right. So the delay in payment, you were in that book also we were talking about it, that how the use of the word advance.
Advance.
Yeah. So the moment you use the word advance, you are cutting off the interest from it and saying that any interim payment is to be treated as an advance and not a payment against work done. But again, there is reversal of that particular decision, or there is another view to it that says that no, you cannot, because it's against work done. How can you call it as an advance when you are getting paid against a work done? Right? I often see many public sector contracts. I'm not sure. I think even in MES also that there is no respite for the contractor if there is a delay in payment. Right? So correct me if I'm wrong. So,
sir, interestingly, CPWD in their one of the clauses, they provide 5% of simple interest on delay in payment. But when it comes to the interim payment, they also call it advance. So, one hand, they are agreeing that they will pay the interest on the delay in RAR, interim payment. But on the other hand, they are saying it is advance. And they are using this word advance just to circumvent the Interest Act, Section 3, where you will not be liable to pay the interest on advance. So, this kind of conflicting and not so healthy clauses, they invariably bring dispute, and they can be easily avoided. A lot of money, gets on hold, and interest of so many stakeholders are at stake when such kind of easily avoidable clauses can be removed from the contract. And you cannot go and start pinpointing to each and every standard form of contract in each and every department. So you need some kind of legislative drafting where you can say that, see, you can't use this word. Advance cannot be used. So it will put an end to all this kind of confusion. So yes, sir, I agree with you. We can keep on counting so many clauses and, so much of confusion. But we all agree on the requirement of a law or enactment.
Just one thing I want to say, if you suggesting that okay, maybe this word advance will be curtailed down, nobody will use, or something will be there, I expect CPWD will come up with some other word and will have the same implication which is there right now.
Yes. So in a way, we have to also see that in future nobody also tries to misutilize or circumvent the intention of the act if it comes at a future date.
That's my greater worry, Mohit, that we should not open floodgates of new set of litigation.
Yes. So I will discuss in the next question, sir, this how to circumvent and how to try to prevent such kind of misuse. So my next question is actually based on this, where I am asking Dr. Murali that if you could throw some light on the best global practices which are existing in the field of construction law. So basically, what we are discussing, it is not something new which has come to our discussion. It has been debated, discussed, enacted, and legislated in all other jurisdictions since last so many 30, 40, 50, 70 years. So probably they have been able to understand their requirements, and they have probably been able to plug all the loopholes. So, sir, if you can just throw some light on this, sir.
Yeah. So, although I am not an expert on how these acts have been drafted in other countries, but I've read through them. And I can say it with confidence that they have certain specific acts that are only for construction projects. Like, for example, you have this in the US. You have something called the Contract Disputes Code, what they call Contract Dispute Code or Act 1978, wherein very nicely they have put down how do you deal with claims and disputes in the contract. Now, let me just give you a small. I'm just looking into that one of the sections. They call it a section 7103C. Very interestingly, this particular section has this line that says that unsupported claims, I'm just reading it there from there, unsupported claims, if found misrepresenting facts, will make the contractor liable to the government agency, sum equal to the unsupported part, plus expenses incurred by the government in reviewing the unsupported part of the claim. Now, look at the way this has been drafted. Now, if you ask any public sector client and talk to them about what do you find as the most difficult part in approving a contractor's claim, the common thing that comes out is many times these claims are inflated. Many times the claims are non-contractual claims. And I don't blame as such the contractor for this, because very manner in which a contractor enters into the game is through something called L1 bidding, the least quoted bid. Now, if you cannot have any amount of contingency that is taken into the bid, because if you start loading contingencies in your bid, then you can never get the contract. So you go with a very thin margin, but the moment there is some disturbance to the scope or some disturbance to the changes in the base assumptions, it's the point which triggers the contractor to come up with a very detailed claim. And in this process, employers consider that the claim is inflated. There is some data. Now, there is some old NHA reports that says that to what extent claims are actually inflated. And why they say inflated is because for a 10 rupee claim, they ask 100 rupees, and finally the settlement is made around 15 rupees, which means that you have wasted the government's time in reviewing such a huge 10 rupees or 15 rupees. Now, who will bear the expenses of the government for having wasted time on something which was frivolous? Right? So that's where this Contract Dispute Act comes into picture, and in the US, and they say that, okay, this is a deterrent, that anybody who wants to submit a claim which has an unsupported component, in fact, they should think twice before they submit it. That brings in a lot of discipline. In a way, it helps the contractor because it becomes easier for the employer to approve it at their end. It is when there is a confusion in the submitted claim that the employer doesn't want to approve it for n number of reasons, and this gets transferred to arbitration or litigation. It is clear, supported, as per contract, no client, no employer, whether private sector or public sector, would stop it. Right? So therefore, this will ease out a lot of problems, this small provision. Another example from this particular Contract Dispute Act, I would say, is that every claim above a particular limit has to be self-certified by the contractor. Before admission of any case in court or appeals board requires the defective certifications to be first corrected. So it puts an onus on the contractor to be right. So that brings in a lot of discipline in the way you submit your contract. So section 7103F of that Contract Dispute Code says that it sets the time limit for the contracting officer to respond against a claim submitted by the contractor. This is very interesting. Now, in most of the contract, there is a time bar limit that is given for the contractor to put up a claim. I think in MES you have 30 days within which a claim has to be lodged. The FIDIC contract has 28 days. Of course, there's another line of thought that goes that whether you can really put this particular timeline to put up a claim, given that there is the limitation period of 3 years available. That's a different story altogether. Again, that's a confusion that needs to be dealt with. So let's not talk about it. Now, the problem is that we have these kind of time limits available for the contractor to submit their claim. But on the other side, how many days within which an employer will actually certify or reject the claim? I'm not saying every claim has to be certified, but decision has to be taken, whether approve or reject. within how many days will this happen? That is not defined in any contract. And this particular law defines this. So even in the absence of, many disputes, if you go to arbitration or litigation, one of the frequent complaints by the contractors, there's no response from the employer. See, I have written 25 letters, I have written 30 letters, there's not even one response from the employer. The presence of this kind of a law that says that you have to respond and the response has to be within a particular time limit can bring in again a lot of discipline. The case becomes straightforward. No need for interpretation after interpretation and confusion or taking precedences from the old, conflicting precedences and all those things. Very clear. Any letter, any request, any approval should be responded within 15 days, 20 days, 30 days, whatever is the timeline that is reasonable. Of course, there can be exceptions under certain cases which can be defined when the law is being drafted. Now, there are so many things. I can keep reading out from the list that I have filtered out from that particular Disputes Act. But this kind of act is also available in this in UK. I think, if I believe, they call it Housing Grants and Regeneration Act. And then it's already a part of the legal system in Malaysia. What they call it as Construction Industry Payment and Adjudication Act 2012 in Malaysia. There are certain acts in Australia, Ireland, which are all specifically dealing with construction projects. Now, I'm not saying that all this is perfect. We can just take it into Indian condition and use it. It needs to be looked into. There can be some problems in that as well. It has to be analyzed, and then it has to be made suitable for the Indian condition, which would take its own time, but the exercise should start, right? So maybe, Mohit, you can also add a few points on this, but this is what I'm able to recollect when it comes to practices from other countries.
Yes, sir. I mean, you are bang on correct, like the way they are dealing in US and UK. So for the discussion purpose, I had noted down few of the acts from some of the jurisprudence. HGCRA, like Housing Grant Reconstruction Generation Act, you have mentioned in UK. So it's nothing but a Payment Security Act, which says that if there's a delay in payment, that what are the rights and obligations of both the parties. Then we have in UK again, Building Act 1984. It lays down the compliances with respect to individual health, safety, welfare, convenience, and it lays down building standards for construction and maintenance. And then you have construction design and management regulations, and again in UK, where it lays down rights and liabilities of various stakeholders such as designers, consultants, contractors, clients. So you have, various basket of acts which are basically looking into different aspects of the construction industry. You have Unfair Contract Terms Act 1977.
Right.
Now this Unfair Contract Terms Act 1977 in UK talks about what are actually the unfair terms which you are strictly prohibited and you cannot put it in your construction contracts. This is very good. Then you have Defective Premises Act 1972. So, the list can go on. South Korea, again, now South Korea has a good basket of in acts and statutes. For example, Building Act, Certified Architect Act, Framework Act on the Construction Industry, Fair Transactions in Subcontracting Act, and they have the Labor Standards Act, Occupational Safety and Health Act, Serious Accident Punishment Act. The list can go on. So what we are trying to convey here is that there is enough learning which has been there globally and which is being practiced. So we are not devising something new. We are not talking about reinventing the wheel. We are just talking that whatever has been the experience globally, India can very well, learn from their experiences, amend them, modify them, and implement them in our cultural and social background, the way we deal with construction projects. But yes, we cannot deny that all is good. We can't say that we are in a very comfortable position and construction industry is not in the requirement of any such enactments or laws. To sum up with sir, now I'll come to the last question of our discussion.
Sorry to interrupt. We forgot to discuss on this TCC, Technology in Construction.
Yes, sir.
I think that would really make a difference if we have something like that in India.
And I also apologize because that was the TCC was the answer to Dr. Niteesh's question that how CPWD can be prevented, or not against anything against CPWD, but any public sector department can be, prevented from using any. So one was I mentioned Unfair Terms Contract Act, where you are strictly prohibited from putting any onerous kind of clause, one-sided clause, and where you are not distributing the risk. Second is TCC, sir. Wonderful example, and thanks for reminding. Technology and Construction Courts in UK, where these are nothing but tribunals with a specific mandate and specific purpose of looking into the construction disputes, where experts who have built their entire career in the field of construction law and dispute resolution, they are made to sit in these TCCs, and they are made to adjudicate upon such disputes. We have a similar provision in a Specific Relief Act, if I remember correctly. But that is not sufficient, because it only empowers, I think, setting up of specialized courts, but not exactly in line with the technology and construction courts. So we are
the commercial courts. You mean to say the Commercial Courts Act?
The Commercial Code Act is different, sir. It is under 2015, but Specific Relief Act actually empowers to set up specialized courts for a specific mandate. But yes, it is not what we intend to say here, that we need technology and construction courts, because there you will be having people who were experts and who have served their entire life and career in the field of construction law and dispute resolution, and they will get to adjudicate efficiently and in a transparent manner all the disputes which are arising in the construction industry, and to resolve any ambiguities. So that will prevent, and all the coming up of any dispute, and also bring larger clarity to all the stakeholders that what to do, what not to do, and where you can go for the early resolution of disputes. So TCC is again a wonderful example, sir. Thanks for reminding me. So as we wrap up, sir, my last question to you is that, summarizing the entire discussion, where do you see we are positioned as of now in global arena in construction industry? And what all can we achieve by having construction law enacted, like the present Indian construction industry in the overall arena of global scheme of things? Your comments.
So I would like to look at this in two ways. One is how construction industry is in India domestically, and how construction industry in India is becoming something like a project export that we are doing, and how Indian construction companies are looking in other countries. So if you look at this, both these are growing. Like, you have foreign companies investing in India, you have Indian companies showing interest in executing projects abroad, and this is growing. And with a lot of technology these days, and a huge focus on Make in India programs, and also huge focus and impetus that is given by the government in pushing this sector ahead, I see that this sector is going to be growing by leaps and bounds in the next few years. At least in the next 5-10 years, there's going to be tremendous changes in terms of getting metros in every cities, improving the entire railway network, the kind of the Delhi-Mumbai corridor that we are talking about when it comes to railways. So the kind of massive investment in infrastructure that's happening, that's all very good. But again, all these things comes problems as well, right? And this problems, when I talk about disputes, when I talk about delays, cost overruns and time overruns, the impact of the industry on the sustainable construction and all those things, the share of disputes are also going to rise, right? And when these things happen, if we still continue with the way in which we are handling with these disputes, it's definitely going to be a problem in pitching India as a country that propels growth, right? So we talk about India becoming a developed country in the next few years, but how will it happen unless we can create a climate that is promoting construction in a manner that is win-win to all the stakeholders who are actually getting involved in it? Now, recently I saw a statement from the minister about India becoming an arbitration hub. right? So there's a huge talk of going on India becoming an arbitration hub. We talk about, the moment we talk about arbitration now, we think about Singapore, we think about London. So in many private sector contracts, you see that the seat of arbitration is in Singapore and seat of arbitration is in London. Why? Because at some point of time, there is probably not enough confidence on the arbitration regime in India. And on one side, you have the push to make India an arbitration hub. But if we don't bring in clarity to all the aspects that we have discussed, then how will we even make it an arbitration hub? So, like the example which I told you, very simple example that I told you, that what is the power of an arbitrator? Whether an arbitrator will be able to think slightly beyond the contract and look into the possibility of resolving the dispute, or is it that the arbitrator should be tied down to the exclusion clauses that are mentioned in the contract? Now, this gives ample scope for the losing party to exploit Section 34 proceedings. And the moment it goes to Section 34 proceedings, the entire purpose of arbitration is defeated. Now, this is where the discipline has to be brought out. And if this law is in place, and as Mohit ji started off, that this law is not only about contractual issues, but it also gets into the domain of dispute resolution, specifically for construction. I think there's one study that says that almost 70 to 75% of arbitration disputes are construction-related disputes. So if India has to become an arbitration hub, you expect a huge inflow of construction disputes into this hub, and then be ready to handle it in a manner that can provide an effective solution without the need for escalating it to the further levels. Of course, if it is something that is grossly improper, that is against the public policy, yes, we do have every right for the court to approach courts and get it rectified. But for all the other things where the approach is made to the court, just because there is a loophole or just because there's an ambiguity in the way the arbitration process is done, then that is actually not a healthy way to look at it. And that's where we need to project this particular construction-related law, which can bring in a lot of clarity in the way arbitration is being done or conducted in the country. So that will give a lot of confidence for others to even put India as an arbitration hub, to put India as the seat of arbitration. So a lot of things can be done. This is on one side. On the other side, with foreign companies coming into India and Indian companies going abroad, a lot of new things we are learning in the process. Like, for example, I was in my college here, we talked about something called malfeasance approach. So there is this issue of concurrent delays that are frequented in construction projects. Not many courts in India talk about concurrent delays. Although there are certain judgments that talk about concurrent delays, the way we deal with concurrent delays is completely different from the way it is dealt in other countries, especially UK and US and other developed countries. Now, there's something called malfeasance approach. So according to which, whenever there is evidence of concurrent delays, I don't want to get into the definition, it's something that you can look into it. So whenever there is an evidence of concurrent delays, there is no question of cost compensation, there is only an extension of time. So time extension is provided. But again, you have something called Society of Construction Law, Delay and Dispute Protocol. You have something called Association for the Advancement of Cost Engineers, AACE protocols. These protocols become very important when you talk about internationalization of the construction projects. But unfortunately, whether it is AACE protocol or SEL protocol in India, they are all of recommendatory in nature. They only recommend, but you cannot enforce that unless the parties have consciously taken the decision to enforce it. I'm sure it will not happen so easily, at least in the public sector contracts. In spite of that, there are contractors who use these typical formulas called Emden's formula, Akeley's formula, Hudson's formula. This has been repeatedly struck down by the court, saying that mere use of formula is not sufficient. It has to be having some kind of proof or some kind of proof for having spent that overhead cost or head office overhead cost. So what I'm trying to say here is that the moment we have a law in place that recognizes certain good practices and discourages certain bad practices, it can definitely propel the growth of our country in terms of attracting foreign investments, and also our country's construction industry becoming attractive to other countries for our involvement into their construction projects that can lead to globalization of the Indian companies, which is good for the country. So in effect, I'm trying to say that this act will create a huge difference in terms of the way we execute the projects and for the good, and it can definitely bring in a lot of discipline in how we resolve our disputes, and probably it can even stop, when if drafted well, it can stop all sorts of disputes that arise because of the way we draft the contract or the way we understand the contract, and put many things into place properly, and then this can help in uh, focusing more on the technological advancement in the construction and seeing the project is delivered better rather than going back and fighting against the other party to settle our disputes. So that's my view on this, Mohit.
Thanks a lot, sir. Something on making India as hub of arbitration, and Honorable Law Minister few days back, I think in London International Arbitration Week, he made this comment.
Correct.
And Bar and Bench, I think they published that article over LinkedIn. And I was reading that article, and below that there was a comment. One gentleman, he just simply wrote, I have been listening this since last 25 years. So there's one liner, a very funny remark when he said that I have been listening this since last 25 years of making India as a hub of arbitration. It has, it's very correct. I mean, what are we doing? Yeah. We are not doing anything. Right. We are not taking any concrete or constructive steps. We are just talking in air, and there is no meaningful development on ground where we should take a streamlined approach towards making India as an arbitration hub. Coming specifically to the construction domain, if I just attract your attention towards the Jews Connect report published in 2023, I believe, it said that the total share of construction disputes globally in arbitration is 2/3, and India it is 3/4. Right. And if the share of our construction arbitration disputes in overall arbitration scheme of things is 3/4, and you do not have any substantive law to govern or to define, then you can understand how much confusion it is going to add. Mosby reports are the report where you begin with. In last 10 years, there has been growth of 120% of project volume in numbers of the project being executed, and 161% growth in the total project value. In April 2015, we had 10 lakh crore of projects going on, which were monitored by Mosby. And as we talk right now, we have 28 lakh crores of projects being monitored by Mosby. And the construction industry provides employment to 9% of the workforce, and it also contributes 9% to the GDP. So then you can understand such a huge sector, and which is propelling the growth of Indian GDP and Indian economy, is not being regulated by substantive and specific statute. Then how international companies or the contractors or they are going to exploit with respect to the disputes, and the interest of all citizens of India and a common man's money will be at stake, because you don't have any certainty how to resolve these in lack of any clear guidelines and acts. So yes, we certainly agree, sir, that we need some kind of specific statutes to clarify these provisions, what we have discussed since last 1 hour. And I once again thanks for your valuable time which you have spared on Saturday, considering that your vacations are going on, irrespective that your wife may not agree that you are not living the vacation in letter and spirit. So I again, on behalf of Law School Dhirubhai Ambani University, extend my heartfelt thanks and gratitude for spending your valuable time with us on this Saturday morning and discussing such an important topic, which is close to not only me and you, but also to all the industry professionals who are student of construction law. Thanks once again, sir. And now over to you, Dr. Niteesh, please.
Thank you so much, sir. Thank you, Mohit Dubey, sir, non-resident fellow Dhirubhai Ambani University. Thank you to Professor Murali from IIT Madras for churning out the whole, if I say in last 40 to 50 minutes, if somebody listens to the podcast, will at least get the idea of all the problem that we have in construction law, and including construction law and dispute resolution, and also what could be the way forward. And just on the fun side, time is essence of contract. I think time is also essence if you want to make something. Like we have an agenda of making a Viksit Bharat till 2047. Making India a hub for arbitration should also have a time frame that, okay, maybe by this we will have a proper system. Otherwise, the one line comment of the person that I'm listening this for 45 years, maybe the same person will do it that I'm listening it from 65 years. So with this, thank you very much, and hopefully we will meet another podcast soon. Thanks to everyone.